A legal history of India, Charter of 1726. The question is, what is the significance of this charter? This charter started the modern legal development in India. If the legal history can be traced to 1600, we can see after coming of East India Company, the modern legal system started, and it was 1726 when the charter came. It started the development of legal system in India. Now, so the East India Company was formed in 1600 with a power, with a life of 15 years. Then it was given a perpetual life, subject to revoking it within 3 years by James I. Then in 1612, the settlement of Surat started. 1690, the settlement of Calcutta started. But it was not until 1726 that the law was very clear. It was very vague. The definiteness in law was not over there. The legal system was very haphazard. The legal system was purely on conscience. It was not scientific. The first step towards modern legal development in India started by 1726. The Charter of 1726 was the first charter which established the jurisdiction, which established the law of English in India. Now there can be certain questions in examination. The noticeable which can be, what are the merits and demerits of judicial system under Charter of 1726, because it was a start of legal development. So if we see it as a reference from today, there would be certainly some demerits, and if we see from the previous legal history, there would be some merits. So what were the merits and what were the demerits of judicial system established under Charter of 1726? That is the first question. The second is, we have to describe what are the provisions of 1726, because according to those provisions only we will be able to understand the Charter of 1726. Now, what were the main aims of issuing this charter, and how far charter succeeded in its main aim? So the ground realities and other thing, whenever we issue a thing, there are certain aims in issuing that particular charter. Then after issuing that particular law or charter, we can afterwards see that how much it was adhered to and where the objective fulfilled or not fulfilled. The Charter of 1726 can be said to be the beginning of new era in the evolution of judicial institution in India. So it was a new era in evolution of judicial institution in India. You have to discuss this. And then Charter 76 introduced English law for first time in Indian soil. Is it true or not? This is quite true. The Charter of 1726 introduced English law for first time in India, and it was new era in evolution of judicial institution in India. So it was approximately even 300 years hasn't been established. The law has evolved into what we see it today. We are having a budding and thriving law system in India. It all started from 1726, the charter from 1726, which was introduced in 1726. So now the question arises, what were the main aims for issuing Charter of 1726? The following were the main aims. The first main aim was judicial administrator and working of court in 3 presidency town was quite unsatisfactory. It was on whims and fancy. So charter was issued to bring a quality in judicial administration, a standardization in judicial administration. Now what happened in this particular charter, that the English law was introduced, and not only English law was introduced, the English crown, the English crown was brought into jurisdiction. The Privy Council was brought into jurisdiction. Now what it happens if there is a law, and if you have given misjudgment, and it goes to the Privy Council, that is to the Britain, then you have to give the judgment very cautiously. So standardization automatically starts because your decisions are subject to the review by Privy Council, and your cases can go to Privy Council and it can highlight the lacuna. So you have to give judgment very carefully, because there is a system, for example, in India of lower courts and high courts and supreme courts. So the quality is automatically being assured because the lower court judge knows that his decision is subject to review by higher court, by high court, by supreme court. So first the Crown's court was brought in India, and second was Privy Council was brought in India. This leads to the standardization of judicial system, the increase in quality of judicial system. So the working of judicial court, which was unsatisfactory, the main reason was judicial administration and the working of court in 3 presidency town was unsatisfactory. Second was, with the growth of company trade and commercial activities in India, the population of British settlement has increased considerably, and therefore more cases were coming to the court for adjudication. So when there are more cases, there is a standardization. The company desired that the power of court should be derived from a competent authority, so that their decision would have binding force and uniformity of judicial administration could be achieved. So what it didn't wanted, because many people, it happened that many people died in India. Britishers died in India, leaving a lot of property. Now, the property will go to the whom? The lower court gave some kind of a decision which was not acceptable to British public. So there has to be uniformity of judicial system. There has to be standardization. And with the growth of people, more cases were coming for adjudication. The judicial administration working court was unsatisfactory in start. It was on whims of fancy of the judges over there. So one of the main was the company was encouraged by successful working of corporation at Madras, and the company also wanted to establish similar corporation in Bombay and Calcutta. So they had taken because there was a successful working of the corporation of Madras. Now company wanted to establish similar corporation Bombay and Calcutta also. Also many Englishmen who settled in India died, leaving behind them considerable movable and immovable property. This created problem before the company relating to distribution and disposal of their assets. Although the Mayor Court, which was established in 1687, these Mayor's Court who were established in 1687 were empowered to decide testamentary cases, but its decisions were not recognized by the court in England because it was the court of company and not of Britishers. The Britishers decided, recognized only the decision by British Crown, and company they didn't decide it. To give you an analogy, for example, Reliance company goes somewhere and makes a huge empire over there in any country. Now the company has got its court. So the decision of a company court would not be adhered by Indian court, because the Indian court, anybody can go to Indian court for litigation and other thing if the company court decides something. So Indian court's jurisdiction has to be brought at particular that places, then only there would be a sanctity. So this happened over there. There was a company court, it was a mayor court, they were established in 1687. They were deciding interstate cases, but there were litigations, and as the settlement was increasing, the litigation were increasing. The litigation were becoming more and more. So there was a need of court in each presidency which could take cognizance of testamentary and interstate succession cases, deriving their authority from British Crown. Thus, in order to solve the above the mentioned problem and to establish an effective administration of justice in company settlement in 3 presidency, The Judicial Charter was granted by British King George I on September 24, 1976 at the instance of East India Company. So now Queen Elizabeth in 1600 created East India Company. James I issued a charter, gave it a perpetual life. Then 1612 the settlement at Surat was formed. 1615 Sir Thomas Roe went to Jahangir, who issued a farman in company favor, and they started living under their own laws. 1690 Calcutta, the Bob Charnock got a jamindari. They created Fort William at Satanati, Govindpur and Calcutta jamindari they got, and they established a mayor court in Madras in 1687 to decide certain cases. But the first legal charter, the legal development, modern legal development, evolution of modern law started in 1726. So to mitigate the bad working of mayor's courts in 1687, the judicial administration was revamped, and the judicial administration working court in 3 presidency town was found unsatisfactory. That was the main reason, main aim, necessitating the issuance of Charter of 1726 was there. Second, the population has increased, and there were many cases. So also East India Company asked to issue this charter so that the legal framework which is acceptable in England also should be created. Third evolves from this, that the power of court should be derived from competent authority so that their decision would have binding force and uniformity in judicial system could be achieved. So Madras was working successfully. Mayor Court of Madras to an extent was working successfully. So they wanted to establish a similar corporation at Bombay and Calcutta. Then there was problem of interstate cases. Though the Mayor Court 1687 was empowered to decide testamentary cases, but its decision was not recognized in British court in England because it was the court of company and not of British Crown. Therefore, company was involved in unnecessary litigation in England at the instant of relative deceased who died in interstate in India. Because the relative deceased now would file that case against East India Company's decision to a higher court, and then there were litigations. They had to hire lawyers over there. Unnecessary litigations were there at the both end. So, to have an effective administration of justice in 3 presidency of towns, the Judicial Charter was granted by British King George I on September 24, 1726 at the instance of East India Company. Now the question arises, what were the main provision of Charter of 1726? The first was establishment of cooperation at Bombay and Calcutta. The Charter of 1726 provided for establishment of corporation at Bombay and Calcutta like the one which already existed in Madras. Thus for each of presidency town there has to be corporation which consists of mayor and 9 aldermen. So we can say that there was a mayor and 9 aldermen, 10 people. For example, in East India Company there was a governing council, general court, you can say, which consists of 24 directors and 1 governor. Here there were 9 aldermen and 1 mayor in each presidency. Mayor and 7 of aldermen were to be naturally born British subject and 2 aldermen can be of any nationality. The first charter appointed the mayor and aldermen itself. Thereafter, a mayor was elected annually by aldermen. The aldermen were to hold office till their life or till their residency in presidency towns. They could, however, be removed by governor in council for reasonable cause. An appeal against such removal could be made to king in council. And the mayor and all aldermen has to take oath of allegiance to the office before governor and council. So each presidency town had a corporation. Corporation consisted of 1 mayor and 9 aldermen. The charter itself appointed mayor and aldermen, first 9 aldermen, and then they were elected by aldermen. The aldermen elected a mayor for 1 year. Annually, the alderman has to elect a mayor. The aldermen they would be holding office for whole of life, or if they move from India to presidency town to some other place, from one presidency to second presidency, if they move, then they cease to hold office. Not only that, if there is a reasonable cause, governor in council can remove them. Though they can appeal against governor in council, against king in council at England, and they have to take a oath of allegiance. So in this way, a system, a democratic kind of a system was established, that there were mayor and aldermen who were taking care of legal system in India, and they were there for whole life until or unless they moved from presidency town for removal. There has to be a satisfactory reason for their removal, and they can appeal for their removal as well. Second was the second provision of Charter of 1726 was civil administration and establishment of mayor court in presidency town. So each presidency town would have a mayor court, which was a court of record. Court of record means for example, in India, High Court and Supreme Court are court of record. They have in Indian Constitution itself says they are court of record. Now, if a court is recognized as a court of record, it gets certain power. Nobody can demean its dignity. It has power to punish its contempt, and its records are considered to be of evidentiary value. If there is a record of High Court or Supreme Court in India, it is of evidentiary value, and they have power to punish their contempt. They are considered in a high esteem. So mayor court were considered to be court of record in India. So the concept of court of record started in India, and the mayor court, as we have studied, that it consisted of 9 aldermen and 1 mayor. So if there has to be a quorum, 1 mayor and 2 aldermen, they consisted a quorum, and they could decide on all civil cases. Now the court also exercised testamentary jurisdiction. It could grant probates of will and letter of administration in case of intestacy. So if a person died intestate, in case of intestacy, it could grant letter of administration. In suppose a person, he dies, and there is a estate of his, and his son lived in England, so they could grant letter of administration. Or suppose a person earned something in India and he died, and there was a will, they could grant probates of will. The court could also exercise testamentary jurisdiction. So will related jurisdiction, civil court related jurisdiction, this type of jurisdiction was held by mayor's court. It was decided that court was to hold its sitting not more than 3 times a week. So it can sit 3 times a week. And an appeal from decision of mayor court lead to governor and council. But in cases which were involving value of subject matter above 1000 pagodas, a further appeal lay to king in council. So if the value of money was over there in pagodas, so if there was less than 1000 pagodas, the king in council, the general and council, governor and council, that was the last resort. And if the cases were more than 1000 pagodas, you can go to king in council. Now, being court of record, the mayor court could punish person for its contempt. The process of court was to be executed by sheriffs. There were sheriffs. They has to execute the process of court. The junior member of court, who were initially nominated but subsequently chosen annually by governor and council. There was no specific mention in Charter 26 as to the law which was applicable in mayor court, but since Charter of 1661 provided that justice was to be administered in accordance with English law, it was presumed that the same law was to be followed by mayor court in deciding the English cases. So Charter of 1661 said that the administration of justice has to be according to English law, and the mayor court started deciding the court cases according to British laws. More so, the privy council came into picture. That was one of the reason the people could now go to king in council if the value was more than 1000 pagodas. Now this was civil administration. Now criminal administration and establishment of quarter session. The governor and 5 senior members of council was appointed as justice of peace in each presidency for administration of criminal justice. So the civil justice would be looked after by mayor and the aldermen. Mayor and 9 aldermen. There has to be a quorum, that is mayor and 2 aldermen. And they were giving decisions. If their decisions, if you are not satisfied by a decision, you just go to governor and council. And if you are not satisfied by governor and council and the value is more than 1000 pagoda, you can go to king in council. As regards criminal administration, the governor and 5 senior members of council were appointed as justice of peace, and they were in each presidency for administration of criminal justice. They could arrest person accused of crime and punish them for petty offences. They also constituted a court of oyster terminer and gold delivery, and were required to hold quarter sessions for trial of all offences excepting high treason for at least 4 times a year. The Charter of 1726 introduced the trial of criminal offence with the help of grand jury and petty juries. The technical forms and procedure of criminal judicature of England were introduced through this charter in India. So in England, when the justice was administered, there were certain technical forms and procedures. These were introduced first time in 1726 in India. There was a grand and petty jury. So we can say that the civil administration by mayor's court, which was court of record, which has power to punish its own contempt. There was a sheriff who would execute the order of the courts, the process of the courts. Then criminal administration and establishment of quarter session. The governor and 5 senior members of the council in each presidency. The governor and 5 senior members. The word is senior member. They administered justice in case of petty offences also. They had power to punish and jail them. Now, another provision was jury in criminal cases. There was a jury. There was a grand jury and a petty jury. So, Charter of 1726 provided criminal cases in presidency to be decided with the help of grand jury and petty jury. Before starting of a case, all the evidence of the prosecution, accusation or indictment was placed over grand jury. Grand jury took a certain time and was to return a verdict whether there was a case for trial or not. In case grand jury returned with a verdict that there was no prima facie case, the accused was acquitted without trial. The grand jury consisted of 23 persons and was entrusted with task of presenting persons suspected of having committed a crime So there was a grand jury, there was a petty jury. The grand jury contained 23%. Each presidencies had a grand jury, and all the acquisition cases, sabut, evidences were placed before the grand jury. And if the grand jury says no prima facie cases, no trial was over there. And this was before the commencement of trial. First, before the commencement of trial, the trial would only start after the grand jury says there was a prima facie case. Then only criminal proceedings started. So the Court of Oyster and Terminal and Gold Delivery contained justice of peace. The Criminal Court Administration Court was which was constituted as Court of Oyster, Terminal and Gold Delivery, contained justice of peace, and justice of peace were governor and 5 senior member of council. And they were holding a quarter session. Quarter session means they would be sitting at least 4 times a year, except in case of high treason. In case of high treason means treason would consider something different. So they would sit more regularly, except in case of high treason they were sitting at least 4 times a year. There was a quarter session, and there was a grand jury and a petty jury. Then there was conferment of legislative power on governor and council. There were legislative powers. The Charter of 26 empowered governor and council of each presidency town. There was a governor and council in each presidency town. From this council, 5 senior council members were chosen. Along with governor, they were appointed as a justice of peace. So, the governor of council of each presidency town has to make laws, bylaws, rules and ordinances for regulation of corporation and inhabitants of presidencies. They would also prescribe punishment for breach of such laws and rules. So such rules and ordinances has to be so framed, and the punishment prescribed for breach thereof were to be reasonable and not contrary to the laws of England, and they could not be effective unless and until approved and confirmed by Company Court of Director in England. So in starting we have read that there was a Court of Director. There were 24 directors along with the governor sitting at England. There was a Company Court. The Company Court decided all the matters. So once they approved these laws and bylaws, and they were not contrary to the law of England, they were made effective. The punishment should be reasonable and shouldn't go contrary to the law of England. So these were the provisions of Charter of 1726. Now the merits of the Charter of 1726. The following were the merits of Charter of 1726. First was establishment of Crown's Court. Up till now, the court were the Company Court. Now, the court were the Crown's Court. So a legal framework was evolved. Now, there was no dichotomy. If the court gave its decision, it was applicable in London also, Britain also, because it was a Company Court. Second was uniformity of judicial system. This charter has for first time established mayor court in all 3 presidencies, that is Calcutta, Bombay and Madras. So in all 3 presidencies, mayor court was established. Third was provision for appeal to Privy Council for first time. For the first time a provision was made to appeal to Privy Council from decision of mayor court. So there has to be appeal to Privy Council from decision of mayor court. Then there was application of English law in Indian soil. So Charter first time introduced English law into Indian soil. Where there was no express provision of law, the judges used to decide the dispute on basis of equity, justice and good conscience. The next was establishment of Legislative Council. The Charter of 1726 first time established local legislative council in the governor. With the aid of this council, used to make bylaws, rules and ordinances for the regulation of corporation and inhabitants of presidency. Before 1726, the lawmaking powers were vested in company, which could be exercised only by the court of director of the company in England. So there was, you can say, delegation of power. The power moved from London to India. So on the account of above merit, the Charter 1726 was a landmark and turning point in legal history of India, and proved to be an important event on account of great significance in sphere of law and justice. The Charter is usually characterized as a judicial charter. Now there were certain demerits of Charter of 1726. If today we see the judges are professional people, but there was appointment of non-lawmen judges. Before 1726, the trader were to be appointed on the office of judge, who were ignorant of law. As judges, their main aim was to bring about the settlement between the contesting party. Even after establishment of Crown Court in 1726, justice continued to be administered by non-professional judges. Thus, the objective of Charter 1726 could not be fulfilled, because there were non-professional judges. The judges were not very professional, they were laymen. Second was no separation of judicial and executive powers. Today in India, the executive is different, the ruling is done by government, and court are independent. Although many attempts were made to separate judicial and executive powers from one another, yet the policy of company was not firm in this respect. The Charter of 1726 did not admit this division, and an intimate relationship was there between executive and judiciary. So this segregation was not over there, and professionalism was not there. But Charter of 1726 was important. The Charter of 1726 has made a long departure from earlier charter and had made some fundamental changes in judicial administration. The Charter for first time established Crown Court in India. So it brought whole English legal lawmaking process in India. It started bringing. Now, whenever court existed, they had their origin from company. But now, by this charter, royal court were having full British recognition, British legal system were established. The charter brought about a uniform judicial system in all three presidencies, and different type of system existed till then, but they were now abolished, and it was uniform. For first time, Privy Council was extended. Its jurisdiction was extended to this country. So because Privy Council came, the introduction of English law came. First time a legislature for each presidency with power of making law was established. Charter of 1726, that is very important in the sense, and this charter introduced into presidency law of English, not only common but statutory. Thus, on the basis of these facts, we can say the Charter of 1726 was a turning point in legal history of India. So this charter introduced many things. Though judges were unprofessional, there was no separation of judicial and executive power, but uniformity came. You can go to Privy Council. The Crown's Court was recognized. Statutory law and common law started coming in. All presidency contained a civil court, that is a mayor court, and justice of peace in case of criminal court was established. Court of Oyster and Terminer it was called. So in all, it started modern legal development in India. That is why Charter of 1726 is very important in India.